The Honorable Justices of the Supreme Court of the State of Iowa, hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. We are here today for 3 cases. The first case is State versus Tyree Brown, and it will be submitted without oral argument. Our first oral argument of the afternoon is State versus Kieffer. And it looks like counsel is ready. Ms. Knipfer.
May it please the court, counsel. Dating for 1 month is not cohabitation. The evidence here will show that it is insufficient to for a finding of domestic relationship between Mr. Kieffer and DA. And a domestic relationship is necessary for there to be a conviction for a domestic abuse assault. To have a domestic abuse conviction, it requires an assault, which the defendant has committed, and a domestic relationship. Here, the defendant was charged under the family or household members alternative, and which means persons cohabitating, parents or other persons related. And so under State versus Kellogg, the court has given us 6 factors to consider when determining whether 2 parties are cohabitating. And defendant submits that only one category is met here. The first one is a sexual relationship. Definitely they were having a sexual relationship. The second is sharing in the income and expenses, but DA was not paying rent. She was not sharing in any other expenses. They didn't share a bank account, so they don't meet the second factor. The third factor is joint use or ownership of property. She didn't have a key to the place. She was not on the lease. She didn't have her mail there, her mail forwarded to there, so they don't meet that factor. All that she had done is brought some clothes and her makeup. She claims that she was moving in that day. He said she just brought some clothes, but whatever the case was, when the testimony on her part also in the transcripts is that she brought a bag of clothes and some makeup. Yes.
So there was evidence that she had moved in. At least the jury could have found that from the evidence that she had moved in that day. Is that right?
That's what the jury found.
I mean, she testified she was moving in that day, right?
Moving in. He said he wasn't, but it's not enough to just like come in and say I'm moving in. First of all, I mean, her idea of moving in may not be within our idea of cohabitation. Second of all, I submit that she's never completed that day of moving in. She brought her stuff over. They were going.
How many days would she need to have lived with him before she would be considered a member of his household?
Consider all the factors together and then weigh them. The court said, I believe in Virgil, that the defendant had lived there for 7 months, but the court's reference to that was almost that wasn't enough for cohabitation. So you have a person here that's alleging that she moved in that day, but I'm saying she never completed it because they went to Sturgis Days, came home, got into a fight, and then everybody left. And
The day before, and then they went to Sturgis the next day, and it was 2 days later. Would she be a member of his household?
I think you got to consider the 7 factors together, and when you look at the fact that she didn't meet these other 5 factors, no, I wouldn't consider her to have moved in. I mean, there are cases where the person has their stuff at the marriage cases I thought were most helpful, but there are cases where the person had stuff there at the home, but you know, maybe they had another home, or they didn't have all their stuff there. It just, again, you just have to weigh all the factors in this case. And moving in for 1 day doesn't make it.
That being in an intimate relation, being sexual with each other, and living together would qualify.
Not alone.
Seriously? People living together, having sex, let's say they've lived together for 6 months and they're living together. And if there's an abusive situation, you don't think that's domestic abuse pursuant to 236?
I think there's case law out there that says that living together alone is not enough. And maybe that's the problem is you're saying living together and having a sexual relationship. But then you would look at the other things to see what.
Let's give me that 6 month living together, living together 6 months and both of them not openly, but they admit they're having sex with each other. Is that a 236 situation?
Another residence?
I just said they're living together for 6 months, having sex. Is that a 236 case?
I don't feel I can answer that because I want to consider the other 5 factors.
Single day across this state. There are all kinds of people living let's assume for sake of argument that's a clear 236 situation. So now aren't we just talking about time? How much time somebody has to live with someone to be considered under the umbrella of 236 if in this case the allegation is they lived together as of the day that the event occurred and they were having sex?
Well, they've been having sex as boyfriend and girlfriend. So on that day she claims she moved in. I still say it's not a 236. With her grandmother. I believe it's a grandmother.
It's kind of, I'm looking at, what is it, instruction 16, and it just says cohabiting, and then it lists a bunch of factors for the jury to consider, doesn't tell the jury how to weigh them. The jury weighed them and decided they were cohabiting. Isn't that something that the jury is entitled to do?
Generally we defer to the jury, but sometimes the jury just gets it wrong. And there is another case out there that I can't think of the name of it, where the court just said no reasonable jury could find that these people were cohabitating. So again, I just think that under this situation.
Starting to cohabit?
I think that's why we have the 6 factors, so we can balance out whether it was cohabitation or not. Relationships are gradual. I guess they're fluid. And then so, you start this relationship and then gradually grow closer and, start staying over, then pretty soon move in. But
I think you got to the 3rd of 6. Can you keep going with 4, 5, and 6 factors?
Well, you hold yourself out as a husband and wife. They're not doing that. Whether there's continuity in the relationship, I submit that this, when you're only been going out for less than a month, you don't even have a chance to establish some continuity. He says she spent the night when she had the day off or on the weekends, and she said she stayed there. I think her words were pretty consistently. I'm not sure what that exactly means, and they didn't specify.
They thought she was pregnant and she was moving in and going to meet his mother that weekend. How did those facts weigh in?
That she took a test that day and it was negative.
At least at one point, they thought she was pregnant and she was going to meet his mom that weekend.
Probably the impetus for her, I don't know, maybe going to move in that day, but they knew at the beginning of that day, at least by that day, that she was not pregnant, and she testifies to that. As I said, she was also living with her grandmother, and then the last one, we do look at the length of the relationship, and this was, they met in May 22nd, and she said they started dating May 29th, and this incident took place on June 25th. And I guess in Virgil, the court noted that I think the jury wasn't instructed on the 6 factors, but the court said that, it might have made a difference because the relationship only lasted 9 months. So the court thought there it could have maybe not found cohabitation, even though the defendant was there for 9 months.
Switch subjects on you here.
Going to?
The state argues that this is a collateral consequence, that this notice for the firearm. Why isn't this a collateral consequence?
Consequence, it's part of the order. As soon as that order for domestic assault is entered, he automatically loses his gun rights because of 922.
It is one of the things that we've looked at, but one of the things that we've also looked at is whether it is punishment or whether it goes to public safety. And I think that you can make an argument here that this restriction goes to protecting members of the public and not to punishing him. Would you disagree?
I think that is, a factor, but I also think the Supreme Court considers it punishment.
The nature of your challenge. Are you challenging only the constitutionality of the notice?
I think, well, the brief is written, and she challenges the constitutionality of the revocation of the gun rights. It was written, it mentions all the pertaining statutes, but it probably focused a little too much on 724, 31A.
Concede at this point that the notice doesn't actually do anything in terms of the prohibition other than giving notice of the prohibition imposed by federal law. Okay. So argues about the notice, it's kind of a non-issue, right?
Right, but the brief is looking at the law as a whole, and again, the notice is not what revokes the rights. And the issue statement is just the revocation of his rights is violation of the Second Amendment and the Iowa Constitution. But it's,
Unless I'm wrong, was written post-Rahimi, is that right? I'm sorry, pre-Rahimi. So now that Rahimi's been decided, what is your best argument that, assuming the firearms prohibition is before us and you're not just challenging the notice, what is your best argument post-Rahimi that it's unconstitutional?
my best argument that is unconstitutional of Rahimi is the permanent prohibition of the firearm. I think it's unconstitutional for a couple reasons, but the federal case laws seem to be mostly focused on the permanent prohibition, doesn't fit within the nation's tradition of punishment for firearms. Like if you had a surety case where they would make a person post bond, or if you had a going arms case, they would take away your weapon but it was always for a period of time.
Well, I think in Rahimi, the court talked about an individual finding of dangerousness. And in this case, your client has been convicted. So arguably, at least, there is that individual finding. Is that wrong?
What I would submit is that in Rahimi, it's a question of whether they present a danger to the person in the future. And it also in Rahimi talks about the firearms being taken away for a limited time period. And it talks about that in a couple different times. And in this situation, we don't have that.
Agree that Rahimi didn't rule out the possibility that a permanent restriction could be constitutional. It just said, hey, this is a temporary restriction. We're gonna hold limit our holding to this.
In terms of how that law was constitutional. So that's why, I mean, and like I said, it mentions that, limited time period multiple times. And so I think that was important to the court, especially if you look at the history that it discusses about the surety laws, the going armed with intent. And when you look at other post-Rahimi cases, they discuss those, and they reject cases like United States versus Diaz is, I think, an outlier case where it does uphold the permanent prohibition, but the other cases appear to be taking a stance that permanent prohibition is overburdensome on the Second Amendment right. I see my time is up.
Thank you very much, Your Honor. May it please the court, counsel. Given the conversation between the court and opposing counsel, I think there's more that we agree about than I expected. We agree that 724-31A is a notice provision that does not infringe on the right to bear arms. It's simply adding Mr. Kieffer to two sets of databases to protect the public in the instance that he attempts to acquire a handgun or a revolver. Now, to play in the space, as it were, if we were to bypass all of the things that might keep us from getting to the question, I think this court could comfortably rule on the state of the law as it's developing that 724-31A is consistent with our history and traditions under the Second Amendment, and, as it's one of the early opportunities to do so, passes strict scrutiny under Article 1, Section 1A of the Iowa Constitution.
If we concluded that because Article 1, Section 1A cannot trump the federal statute, correct?
So to be perfectly clear, Article 1, Section 1A can have no effect on 18 U.S.C. 922, a federal prohibition that will exist regardless of the outcome of this proceeding. So no, Article 1, Section 1A can't affect the federal statute, nor can it affect the Second Amendment to the United States Constitution.
Following up, I think Justice McDermott was starting to get at it. I mean, is this even really part of the sentence?
Literally, the line that this entire appeal hangs its hat on is the one sentence, "A separate order will follow," on page 4 of the judgment. That separate order, not a part of the judgment, followed that same day. But it is not the judgment. It is not a part of the sentence. It is literally a notice to Mr. Kieffer that his name has been added to the FBI and the DPS databases. And that's part of the reason why I think we don't need to dwell long on, oh, please. You bet.
We have some language from State versus Warner from 1975 that says a consequence is not collateral if it represents a definite, immediate, and largely automatic effect on the range of the defendant's punishment. And I've kind of tried to sift through some of our collateral consequence cases, and I'm not sure that that particular rule or those particular elements are the things that kind of drive how our outcomes have been reached. What's your take on that?
You that the cases are not necessarily clear, and I myself have struggled with the idea of, does being added to a watch list or being disarmed truly qualify as punishment?
These words, definite, I think this notice is definite, it's immediate, it was immediate, and it's largely automatic.
Even then, part of the conversation that you were just having with my opposing counsel was this idea of, well, what are we actually charging here? If we want to say that 724-31A is an automatic thing, I won't fight you on that. Under the statute, once the judgment is entered, the notice is given. But 724-26-3 also requires an in-person notice to the defendant. And we wouldn't say that that is punishment. That's just notifying the defendant that he is now subject to restrictions yet to come. And part of the reason why this is clearly collateral is that Mr. Kieffer is attempting to attack every statute which prohibits him from having a gun, none of which he's been charged with. We don't even know if he owns a gun. And it's just too collateral on direct appeal with no record to really engage with it. So I agree that the court's cases aren't super clear, but I would say that whether it's a collateral consequence or somehow notice suddenly falls into punishment territory, it's not truly punishment. I don't think it could be fairly construed that way.
It seems to me there might be two different issues. It might be a direct consequence, not a collateral consequence, but that doesn't mean it's part of the sentence and that he can appeal it along with, what he's raising here, which is sort of this underlying guilt or innocence issue.
I think if we're looking at the federal cases where a lot of the development in this area is going, these are people raising motions to dismiss. They're seeking injunctive relief and declaratory relief. These are people who are, proceedings are underway where there are actual stakes at play rather than us playing with ephemeral ideas of things that haven't.
On it, but the state is paying for Mr. Kieffer's lawyer. If this is not really part of his conviction and sentence, the state shouldn't have to pay for that appeal. He can go out and file, do whatever he wants.
The reason that I think this is interesting is that 724.31a even includes a statutory mechanism by which if you feel that you shouldn't be on these lists, you can petition to be removed. And if you are rejected, then we're already into 17A territory, where you're reviewing what the Department of Public Safety has done. Or if you look at 724.21a, had Mr. Kieffer attempted to acquire a firearm, had been told no because of the result of the National Instant Criminal Background Check, he would have to pursue a federal remedy to attack the fact that he's on the federal list.
Rahimi dispositive of any Second Amendment claim here?
Rahimi, and I think the Supreme Court was attempting to demonstrate, but be clear about the contours of what it was demonstrating. It was applying Bruin's test to a set of circumstances, but it was not, categorically saying all things forward. It left that work to the district courts and circuit courts and our court. But I would say that Rahimi is extraordinarily unfavorable because if we look at Rahimi, there we're talking about something that hasn't actually happened yet. We're talking about a person who's subject to a no contact order, and while that is a prohibition under 922, it's different here because a no contact order in that case was based on an allegation that he posed a threat of harm. Here, Justice McDermott, I think you were pointing this out, Mr. Kieffer has been convicted not once but twice of domestic abuse assault. We've proven beyond a reasonable doubt that he is the type of dangerous person that our legislature can determine categorically cannot have a firearm. I also think that just to hit all the bases.
6 month having sex, do you think that's enough to get somebody under the 236 umbrella?
I mean, I think the important thing here is that no hard date or time is ever going to be truly satisfying. And I think this jury here had the right instructions. As the court directed in Virgil, give them the Kellogg instructions defining domestic relationship, cohabitating household members. And here, where everyone's expectation is that she is going to be living here, she calls A.J. Furnow her roommate and says that he helped her. Everyone's expectation is that they are in an intimate sexual relationship, living in the exact same room, sharing that space, and I think that that puts us safely inside domestic.
Case 236.2 sub 2 sub E sub 1 sub whatever. A person may be involved in an intimate relationship with more than one person at a time. So doesn't that also imply that it doesn't have to be a consistent, not only period of time, but relationship either?
And to be frank, I think in 2024, Kellogg is now at least 20, 25, 30 years removed. We should be encouraging the jury to consider all the facts, their common sense, to determine whether or not a domestic relationship exists.
What you're saying, but I do have misgivings. So this is not unique to this area of the law. But what happens is we write an opinion, and there's a bunch of factors, and they're just sort of reasoning in the course of the opinion as to why there was or wasn't an issue for the jury. And then this list of factors, which we were using more to just explain our legal theory thinking, then goes to the jury as if it's a set of facts. And I don't think it's all that helpful to the jury to just give them a list of factors. Is it really?
I think it can be helpful, especially because, as the court has previously said, domestic relationship is a term of art. I'm trying not to pick too much of a fight with you, Justice Mansfield, because Virgil's of recent vintage, and counsel was not the counsel guaranteed by the Constitution by failing to ask for that instruction. I think if it's helpful to jurors and it helps them resolve the specific facts of their case, it's fine. They can resolve it, and we should defer to that determination, especially here where we have her statements in front of them that she expected to live there, that she believed she was pregnant for a time, and said that a subsequent test. But then if we look at the statements of everyone involved that night on recordings, Mr. Kieffer apparently believed when he was talking to police officers that she was still pregnant. And the jury got to listen to Mr. Kieffer vehemently deny that she lived there, that she was moving in, and that she was a resident. And they convicted anyway, suggesting to me that they didn't believe him and they believed her. And again, we weren't there, and I think we should defer to their determination.
When you talk about whether or not she was pregnant and the belief that she was pregnant, that has something to do with minor children, perhaps, as well. Is that correct? Is that what you're getting at?
It just also informs the nature of the relationship, its length, its continuity. It's a fact to be considered by why is she now moving in? Possibly because they are, it is a small space, as you've seen from the video, but working on a family. We don't know that per se, but I would like to just briefly talk also about Article 1, Section 1A while I have you here. I think other courts' experiences with strict scrutiny amendments to their constitution are highly informative here. I think if we're looking at Louisiana and Missouri, who have already resolved several of the issues that this court is going to receive in the coming months, I think they are quite persuasive in showing that when you are adopting an amendment to a constitution, the existing laws on the books, the fact that they are not being struck at the same time tells you something about what the people who have adopted that amendment believe. It tells them that if they had wanted those other regulations, those prohibitions on firearms, the no contact orders.
I mean, this is sort of the reset argument that I trotted out in, I've advanced in a couple of cases. The problem with it here is strict scrutiny has a pretty established meaning, a very established meaning. And then to say that we should deviate from that meaning because that might strike down some laws, that's troubling.
Why I'm suggesting that we look at what other states' experiences with these kinds of amendments to their constitution and their strict scrutiny review of their felon in possession laws, their juvenile in possession laws. They have affirmed those laws and found that they withstand strict scrutiny because, as here, there is a compelling government interest and it is tailored to serve, actually serve that interest. Sorry, I misinterpreted a question. And I believe that 724.31a, to the extent we're playing in this ballpark, is in fact narrowly tailored to the interest at play here. We are talking about a weapon that is, without doubt, probably the most lethal in domestic violence encounters. The statistics I've offered the court show that when a gun is involved in...
Respond to the defendant's argument that the problem with this somewhat is that it goes on forever.
The answer to that question is in the class, in the process received, and the answer, and then also, again, just our interest involved. Here again, we've demonstrated not only the lethal effects of combining firearms with domestic abuse, we've demonstrated the recidivism, which is the real risk and why disarmament, if that is in fact the effect of 724.31a, is important here. The process is also important. I've skipped a step, but I'll come back to it. Mr. Kieffer has received the full panoply. He's here in front of the Iowa Supreme Court. He's had a jury determine whether or not he is in fact a member of a class of people that pose such a risk that we should disarm them. And that goes back to the class question, which is that, is this a class of people that the legislature could determine should be disarmed? And again, that it's a bit of a nexus, but ties back to our compelling interest. And we have offered the court recidivism statistics, fatality statistics, specifically from Iowa, involving 386 victims and several, I believe 74 bystanders, not to mention the harms that could befall police officers responding to these calls.
Issue before us, though. This is only a challenge to the sentence. There is no challenge to an inability to have restoration of rights. There's still a protective order in place. which makes it a current prohibition that can't even be removed under currently existing law. I mean, don't we just need to pass on whether 724-31A notice violates some sort of right? Isn't that the only issue?
And it's brief. I'm just, in every brief before this court, we will offer multiple off-ramps to the issue before we get to the Constitution, which is consistent with constitutional avoidance. But I'm here, and I'm here for a conversation. And I think that if you were not to take the off-ramps, not to decide the issue on something beforehand, we would still pass the hardest version of this test that the state's ever been presented with. For the foregoing reasons, I would ask that this court affirm Mr. Kieffer's conviction. He was in a domestic relationship with DA when he choked and struck her, causing bodily injury. And because we have proven beyond a reasonable doubt that he is the sort of person that should be disarmed, his challenges, if you reach them under the Second Amendment and Article 1, Section 1A, must fail. Thank you for your time and your consideration.
Leaving all my pins up here. On the question of dangerousness, I mean, he has been found in the past to have committed this crime, but we're submitting that when you're talking about classes of defendants, such as in the felony statutes, we all presume that felons are dangerous, but there's different, some felons aren't violent. Well, also in this case, this is not very articulate here, but if you look at, he's been convicted, yes, he has 2 domestic assaults, but they were committed at the same time under a night that is pretty strange. But anyway, it's not talking about whether he poses a serious threat in the future. And if you look at his sentencing, he was given 2 years self-probation. He was given time served. The prosecutor and the district court didn't seem to be too concerned about this repeating. And
Is why you're drawing that conclusion. I would maybe perhaps think jails are full, everybody gets, or prisons are full too. They get kicked out early. There's a protective order out there, most likely, if he was convicted of domestic abuse. So the court doesn't need to worry about that relationship. So I guess I'm confused why you would draw that conclusion.
saying is, I don't think the court is as concerned in his situation that he will be a repeat offender. Obviously, if he does repeat, I mean, he's going to jail. So there's that safeguard there. But the court didn't send him to jail for 2 years or prison for 2 years. And that's what I guess I'm trying to point out, is that there are degrees. And
What is the path for us to apply the new Iowa Constitutional Amendment 1A here? Or does it apply?
in strict scrutiny, I mean, I think the strict scrutiny statute, I mean, it was that standard was in existence when that legislation amendment was passed. And so, I mean, we just have to determine whether this was a narrowly tailored punishment. And so lifetime prohibition of a fundamental right just cannot be permanent.
Say that.
There is no limitation in 922G9 for taking of the firearm. The federal courts have treated it as a permanent ban also.
922G, if that's the only basis for his, the prohibition, how can the Iowa Constitution override what the federal Constitution says about a federal statute?
They can say that, I mean, as it's applied through 72426, that the statute is unconstitutional. And so the Iowa courts and agencies, sort of like the federal marijuana laws, we don't have to enforce that provision, but I mean, it will still be enforced on a federal level, so federal agencies could enforce it. Does that answer your question?
Well, I mean, let's say we did hold that the Iowa parallel statutes prohibiting him from possessing a firearm under Chapter 724 were unconstitutional. That still doesn't resolve the federal prohibition question under the Iowa Constitution.
Right, I mean, we would be,
Prohibitions here, and the Iowa Constitution can't trump one of them.
right, but if you say that the Iowa under the Iowa Constitution, that it's unconstitutional, then the state agencies, I would say, wouldn't enforce it. Like in Colorado, they have their marijuana laws and it's legal, but in the federal level, marijuana is not illegal or is illegal, excuse me. So there's different enforcements going on. Okay, I see, all right, I just want to point out one last thing, and that is the case that I filed yesterday. I thought the point in that case that I liked was that the court said, when you're talking about classes of persons, that there should be some means and opportunity for that person to be able to show that they're not as dangerous as the presumption is in that class. And that is what I think we need here. I see my time is up. So for the reasons stated here and in the brief, defendant respectfully requests this court to reverse his conviction.
State versus Kieffer is hereby submitted. We'll take a brief pause before our next case, Ciancio versus